back to This Week in Immigration, our in-depth look at what really mattered this week in immigration policy. I'm Hunter Hallman. Today on the show, we discuss important court updates on DACA, the oral arguments in the Supreme Court travel ban case, extreme vetting, and the hot-button issue of the Migrant Caravan at the southwest border. Before we dive in, you can subscribe to this podcast and all of BPC's podcasts on Apple Podcasts, Google Play, or wherever you get your podcasts. You can also stream on our website at bipartisanpolicy.org. And while you're there, you can find more information about all the topics we discussed today. Just go to bipartisanpolicy.org/immigration. It's going to be a jam-packed half an hour, so let's get started. Our guests today are Theresa Brown, BPC's Director of Immigration and Cross-Border Policy, and today we also welcome Jessica Michek, who is a policy analyst on the National Security Project at BPC. Welcome, guys.
Hi, Hunter.
Thanks for having me.
So let's start off with the recent news on DACA in the courts. Last week, a federal judge in Washington, D.C. ruled against the Trump administration's decision to end DACA, saying it was arbitrary and capricious. The judge ordered the administration to start the program with a 90-day window. So what does this mean for DACA?
So what it means is that the judge really came down hard on the administration over the way it ended the program. There's a law that governs how the executive branch operates on all of its things called the Administrative Procedures Act. It's a very arcane piece of law, but basically it says that the government cannot act on a whim. It has to have process, it has to have policy, and its decisions can't be arbitrary or capricious. And what the judge essentially said is that the government didn't provide sufficient legal reasoning as to why it had to end the program the way it did. It didn't provide enough notice to individuals who had been reliant on the program, and that was unfair. So he gave the government 90 days to come up essentially with a better legal rationale for why they needed to end the program. And if they didn't do so, he was going to order the entire program restarted. So we had some previous judges in California and New York who said the government had to accept people applying to renew their status. So that's been going on for several months. But this would allow people who are newly eligible for the program to apply.
So what does this decision mean for those other court cases on DACA, the ones that held that the administration needed to start accepting renewals again?
Well, we won't know until the 90 days is up, but presuming that the judge's order kicks in, basically those other injunctions would stand. The government would still be processing renewals, but would now be processing new applications. It's pretty certain that the federal government will appeal this decision as they've appealed the other ones. And the Supreme Court earlier rejected a plea from the administration to very quickly take up the issue and send it back to the district courts. So as it makes its way through the appeals courts, this might get the Supreme Court to take it up a little sooner, but there's another court case that would probably prompt it faster, and that's what's happening in Texas.
So just this week, the state of Texas and several other states made good on their threat to sue the administration over allowing the DACA program to proceed at all, arguing that the program itself is illegal since Congress didn't authorize it. So what does this mean? Does this nullify the D.C. judge's decision?
Well, the judge in Texas hasn't done anything with it yet. The state's just filed it. But why this is important is that D.C. judge, in his ruling that the administration acted in an arbitrary and capricious way, specifically called out the administration for acting on a threat of a lawsuit. Now, if we go back to September, we remember that the Attorney General came out and said there were these states that were threatening to sue against the program. We believe those states would win. And so we're ending the program. But there wasn't a legal rationale there. There wasn't a memorandum that outlined the strengths of the case and why they thought that was true. And the D.C. judge called that out. So now those states that threatened actually did sue. And that may very well prompt a reexamination of the D.C. case. Certainly the government, when it's appealing the D.C. case, will probably raise the fact that this changes things by this suit being filed in Texas. It's being filed in the same district that ruled against the Obama administration's implementation of the expanded DACA program and the so-called DAPA program, which was for parents of U.S. citizens in legal permanent residence. So there's a fairly good chance that if they get the same judge in the same district, it may very well rule against the DACA program. We'll have to wait and see.
So I'm interested in another piece of that, which is that I've heard several news reports say that, it's possible that the Trump administration worked with these attorneys general to bring this case to kind of nullify that legal argument. Would that be a problem if that were to be the case?
It certainly would be irregular. And Senator Dick Durbin of Illinois, the number 2 Democrat in the Senate and a leader on the Senate Judiciary Committee, actually wrote a letter to Attorney General Sessions asking for information about whether or not he had, in fact, coordinated in any way with the attorneys general. During a Senate hearing over the ending of the DACA program last year, the Attorney General faced questions about whether or not he had been in conversations with these states' attorneys general. He sort of declined to answer, but Ken Paxton, the Texas Attorney General, who's lead in this case, had acknowledged there had been some conversations back and forth. So it's certainly irregular that parties that could be antagonists in a court case, because it would be up to this government, the Trump government, to defend the DACA program in that Texas suit. And so that makes them antagonists with the Texas. So that would be very unusual. And I think there'd be a lot of questions raised about that.
Okay, great. Thanks, Theresa. In more news out of the court, the Supreme Court recently heard oral arguments on the president's latest version of the travel ban. How did that go?
Well, so this is travel ban version 3.0 for those who are counting. The first travel ban was the one that was issued in January of 2017, right after the president was inaugurated, the one that caused the chaos at the airports and had a lot of injunctions against it immediately. The administration created a second version in March after some initial court cases went against it. That version was the subject of another injunction that kept it from being implemented. They subsequently got an appeal of that to the Supreme Court that allowed most of that to go into effect. This is the third version, and this version comes after a process that the administration went under to basically go out to every country in the world and figure out how that country is coordinating and cooperating with us on information sharing relating to terrorism, criminality, and the risk that any of their citizens may pose in coming to the United States. So this was a longer executive action and longer order when it went to effect, but the number of countries was reduced. So it now applies to 5 majority Muslim countries. It had applied to Chad, although Chad was recently taken off the list, and North Korea and Venezuela. But it's also not a blanket ban. Most countries in the world, certain of their citizens can come in certain categories. So, for example, North Korea and I think it's Syria have a total ban on anybody coming in. But the rest of the countries might be, for example, allowing students to come in or workers to come in, but you can't come in for vacation or business. You can't come in as an immigrant. So it's a little more nuanced. The oral arguments asked a lot of questions of both sides, but most of the observers seem to think that the justices were very sort of concerned about trying to second guess the government's decision that this really is a national security issue. The underlying authority that the government cites to do this is a provision of the Immigration Act that basically says that the president can suspend the entry of any alien or class of aliens when he deems it in the national interest. So a lot of the questions were about whether or not the president is justified in saying these are national security issues and therefore it's in the national interest. And most importantly, whether or not they can go back and look at his statements in the election or early in his tenure where he talked about a Muslim ban to say, okay, he's saying it's about national security, but it's really about this discriminatory religious ban. Notoriously, it's hard to tell how justices are actually going to rule from their oral arguments, but most observers are thinking that the government did a pretty good job at defending its case, and the judges are not that eager to sort of break open this door to look at other rationales when the existing national security rationale has a decent basis.
So if you were a betting person, do we think the Supreme Court will uphold the travel ban?
I hate to bet on these kind of things. I don't know. I think that the government has a fairly strong case on this version. I think it's stronger now than it was before because there actually was a process put in place. They actually did go out and look at these countries, and they are talking about some significant terrorist threats. I think whatever it is, I bet it will be a close 5-4 decision, and we'll see how it comes out.
So what's the on-the-ground impact for travelers right now who are affected by this ban?
So for those that have been covered by the ban since the Supreme Court let it go into effect, a lot of them are not able to come, particularly immigrants. That's those who are coming to live permanently in the United States to get a green card. They're completely banned from most of these countries, and that includes people coming to work, people who have family members here. So that's a significant hardship. But beyond that, we have seen a significant decline in applications for visitor visas and other sorts of visas from a lot of these countries and, frankly, worldwide. And so just the sort of pronouncement of these bans, all of the publicity surrounding them, I think for a lot of people in the world, they're sort of wondering if America is drawing back the welcome mat a bit.
Thanks for getting us up to speed on that, Theresa. So now I turn to Jessica Michek. Welcome to the podcast, and thanks for coming on to talk about extreme vetting, which is really a perfect intersection of immigration and national security policy.
Thanks for inviting me on.
So we just talked about the travel ban. The same executive order that initiated that ban also ordered the government to begin, quote unquote, extreme vetting of travelers. And last month, the administration announced a new national vetting center. What do they mean by extreme vetting, and what will the National Vetting Center do?
I think there's a lot that's uncertain still about the National Vetting Center. The U.S. government already extensively vets travelers, so it's unclear how this agency will increase that scrutiny. Travelers are screened against terrorism watch lists and other national security databases. Information about criminal backgrounds or links to extremist groups are shared with the U.S. government. And so when asked about deficiencies in the vetting process, officials often point to the fact that we need to better screen travelers' social media information. But it seems like that could be incorporated into already existing agencies that screen travelers. So it's a little bit unclear as to exactly how this organization will define its purview and how it'll interact with already existing government agencies that exist for the same or similar purpose.
Are foreign terrorists as big a threat as it might seem from the rhetoric that's around extreme vetting?
To make a policy about vetting or counterterrorism, you do have to look at the current state of the terrorist threat. Is the threat that already radicalized individuals are seeking to enter the United States to carry out attacks? Or is the threat more that people who are already residing in the United States are being radicalized domestically and inspired to carry out attacks? If you look at two recent successful or foiled attacks in New York City in 2017, I think that illuminates the current terrorist threat. In the truck attack in New York City in October 2017, the individual who carried out the attack was foreign-born and immigrated to the United States in 2010, but he self-radicalized while in the United States. The attempted suicide bomber in New York City's Port Authority bus terminal in December 2017 was also foreign-born, and he'd lived in the United States since 2011, and he'd consumed terrorist propaganda and self-radicalized while in the United States as well. So in these cases, it's unclear how any amount of traveler screening could have prevented these attacks. It seems like the only thing that would have been a crystal ball. So if the question isn't one of vetting, then it's more of law enforcement. How do you detect individuals who are planning attacks and disrupt them before they carry it out? It's also a counterterrorism question of how do you prevent terrorists from spreading propaganda online that provides inspiration and instruction to individuals who might be seeking to carry out attacks, often without any contact with known extremists prior to carrying out these attacks. And then moving back even further in the process, it's a question of how do you prevent terrorism? How do you counter the ideology that terrorists and their supporters spread? And how do you make the cause of terrorism seem less appealing?
So you alluded to this a little bit before, but what government organizations and protocols already exist to vet travelers?
A major government agency is the National Targeting Center, which was set up in 2001 after the September 11th attacks. And it exists to screen travelers and share information among federal databases. This center begins screening travelers as soon as they book their flights to the United States. Officials have stated that this new center will work closely with the National Targeting Center, as well as other federal agencies, such as the Terrorist Screening Center and the National Counterterrorism Center. But one way that the National Vetting Center seems to be slightly set apart from some of these agencies is that its role isn't just to screen travelers. It will also have an increased role in screening individuals already present in the United States who might be applying for citizenship or residency.
Interesting. So what about the effect of all this on deterring other applicants who aren't terrorists from coming to the United States? Are we balancing the interests here?
I think it's hard to say. I mean, I think, when you make it difficult for people to enter the United States, then it does have a slight chilling effect on travel. And I know in conversations that I've had with people who aren't U.S. citizens, they are concerned as to whether or not they will be able to enter into the country if they try. And so it deters people from coming here for tourism or for business. And even if you just make the process take longer, then that is also going to have an effect on whether people spend money here or do business here. So I think there are a lot of interests to consider in balancing economic interests and national security interests.
Great. Thanks for helping us understand that, Jessica. Finally, this week, we're going to talk about the so-called Migrant Caravan that arrived in Tijuana at the U.S.-Mexico border, and members have also begun to arrive at the port of entry to seek asylum to the U.S. Theresa, the president has called this a quote-unquote invasion, and the attorney general says they're here to undermine our laws. What is this caravan, and are they breaking laws?
So I think there's been a lot of misunderstanding of what this migrant caravan is. There is a U.S.-based organization called Pueblos Sin Fronteras that has been organizing what they have called a caravan, but is really a pilgrimage march in southern Mexico for the last several years of migrants. And their purpose is to call attention to this migrant flow, to the, in their words, the plight of these migrants as they travel through Mexico, to try to offer them some protection in numbers, because many migrants who make their way through Mexico are victims of crime, of violence, of other issues in Mexico. And so by binding together, they can protect themselves better. The unusual thing that happened this year is the numbers. In past years, it's been a couple of hundred, and not all of them have come to the United States. They've ended up somewhere in Mexico or just sort of fallen apart. This group started out at well over 1,000. And so just by the size and nature of it, it became sort of more noticeable to the press and to this administration. But the reality is that most of those people never were going to come to the United States. An awful lot of them either decided to stay and apply for asylum in Mexico, were apprehended in Mexico and deported back to Central America, or otherwise sort of fell off the thing. So the final group that arrived in Tijuana was maybe a couple of hundred, and it's a very small amount. So to call it an invasion is a little, I think, exaggerated. The last question you asked is very, very important, though. U.S. law requires that if someone presents themselves at a port of entry and asks for asylum, we must consider that application. We have to interview them. We have to decide if their fear is credible. We have to decide if we think they have a good case for asylum, and it must be heard. That is our law, and that is international law. So by presenting themselves at a port of entry, they are not violating any laws, any American laws or any other laws. A few of them have tried to come in between the ports of entry. And yes, arriving between a port of entry is a violation of American immigration law. But even there, if they are apprehended and then ask for asylum, we also must give them a chance to tell their story and see if they're qualified.
So the port of entry reportedly said that it will take them more than a week to process the 150 or so applicants for asylum, several per day, and that they have to wait in Mexico until they can be processed. Why does it take so long? And is it really a matter of capacity, or is this more of a way for the administration to slow the process down to deter more people from applying?
So a couple of points are worth mentioning here when it comes to the capacity of the port. First of all, these migrants are not the only ones applying at that port for asylum. The port of entry at San Isidro, California, has been averaging about 200 asylum applicants a day for quite a while, from many, many countries, not just South America, but from Mexico and Haiti and other parts of the world. So they were already pretty much at capacity before this group came. What happens logistically at the port of entry is you line up with everyone else who's trying to enter the United States to see an inspection officer. When you reach the inspection officer, you would present whatever identity documents you have and say, I would like to request asylum. At that point, you're sent to what's called secondary inspection, where another officer will basically process you. It's a matter of getting your biographic information, collecting biometrics, copying all your documents, filling out every piece of paperwork you can imagine that every immigration process requires. And that's just the beginning. At that point, you're probably going to be detained there at the port of entry until an asylum officer can come and talk to you. So the next step is that a trained asylum officer from U.S. Citizenship and Immigration Services would come and talk to you about your claim for asylum. And that officer's job is to determine whether or not you are credible, that your fear of going home is credible, and that you have a probable asylum claim. Now, just because you're fleeing violence or crime or poverty, that's not grounds for asylum under the law. You have to be fleeing persecution on account of your race, your religion, your nationality, your sex, membership in a social group, and generalized crime or violence may not be sufficient to qualify. So that's really the threshold. Then once that asylum officer finishes that interview, if they find you have credible fear, you're then referred to an immigration judge to make your asylum case. At that point, you may be sent to a detention center somewhere else in the country because the port of entry can only hold you for 72 hours, or you may be released with an ankle bracelet and told to report to an immigration judge somewhere. At that point, it may take 1.5 to 2 years before the immigration judge hears your asylum claim. So now, understanding that entire process, you can kind of understand why the port of entry is saying we have some capacity issues. However, and here's what I would say, knowing that this caravan was coming, knowing that the port was already at capacity, the government probably could have sent some additional people down there, made other arrangements for detention of these people while these interviews are happening, and they have chosen not to do so. So by doing that, yes, they are sort of exacerbating a little bit. But I would make sure people understand that the process just does take a long time and resources.
So the administration also announced previously that they would prosecute people who tried to enter illegally and anyone who files a false asylum claim. And we saw that the U.S. Attorney in California did prosecute about a dozen immigrants who were apprehended by Border Patrol trying to cross into the country several miles east of the point of entry. So what will happen to them?
So these are people who chose not to file for asylum at the port of entry. They chose to try to sneak in, which, as I mentioned, is a violation of immigration law. And that violation can be prosecuted in a court of law as a crime, or they could just remove you from the United States. What the Attorney General said is we're going to choose that first option more often than we have in the past. A conviction of a crime of illegal entry, that means coming in at a place other than a designated port of entry, carries with it a fine and a 6-month prison sentence. It's considered a misdemeanor. If you are convicted of coming back after having been deported between the ports of entry, that's called illegal reentry. That can be punished by a fine and up to a year in jail and is considered a felony. And there was at least one person in that group that was prosecuted for reentry. However, as I mentioned, if they also have an asylum claim before that prosecution happens or even during, that asylum claim still can be processed. So you could be prosecuted for illegal entry and still have a valid asylum claim, as awkward as that sounds, as contradictory as that sounds. The point is that the government is trying to deter people from coming in illegally. If you're going to file for asylum, they want you to do it through the ports of entry, through the legal way. That having been said, this group of people either felt that their asylum claims were not valid enough, didn't want to wait for the port process, or any number of other reasons and chose this.
Thanks for unpacking that for us, Theresa. I think that's enough for 1 week. Thank you all for a great episode. Please take a second to find us on Facebook by searching Bipartisan Policy Center or on Twitter at BPC_bipartisan. And don't forget to subscribe to this podcast, as well as all of BPC's podcasts on Apple Podcasts, Google Play, or wherever you get your podcasts. Just search Bipartisan Policy Center.
And I want to take a special moment to say thank you to Hunter. This is going to be her last This Week in Immigration with us because she is leaving the BPC to go off to bigger and better things. Hunter, thank you so much for helping us kick this off from the beginning, for being our co-host and a steady hand on this. We wish you all the best. And I also want to say welcome to Emily, who's our new producer for the time being. And thank you very much, Emily, for producing our podcast.
And I just want to thank all guests, past and present, of course, our producer, Emily, and my top-of-the-line co-host, Jordan. It's been just a lovely, great experience.
Thanks so much. And we'll see you again next week on Immigration.